Well, she got everything wrong, just about everything wrong. The situation was that we had raised a preliminary point that the case should be struck out. The case that was brought by Mr. Robinson was a case known as a constitutional motion. That is to say, he is moving the court, asking the court to grant him relief because some constitutional right which concerns him has been contravened. He cited as the basis of his claim Section 105 of the Constitution. Section 105 of the Constitution is a very important section, but what it does, it establishes the Police Service Commission, and it gives the Police Service Commission the power to appoint persons to office in the police service, to, of course, disappoint them from office, or to suspend them from acting in the office. That is all that Section 105 does. The way I would put it, it creates the Police Service Commission. It does not create the Police Service Commissioner. So the section that he was claiming under in no way gave him any rights. All the rights it gave was to the Police Service Commission. So he had no proper basis to bring a complaint that some constitutional right of his was being violated. Now, the judge said, well, let me put it like this way. When we make a preliminary point like that, it's a very simple thing. We say, look at what this guy is claiming for, look at the Constitution, and you can see that clearly there is no constitutional claim that can be properly brought or maintained. The judge says, oh, you didn't come right. You did not bring no affidavit. You did not bring no evidence. Well, when you are seeking to strike out a motion on a preliminary point like that, you don't need no evidence. It's simply looking at what the other side has brought. Look at the standard against which we ask the stuff to be measured. You read it and see if it meets the standard. So she said that we did not properly bring the preliminary point to the court. We say she was wrong on that. The Court of Appeal agreed that she was wrong on that. But moreover, she herself, very early in the judgment, she indicated that the constitutional motion brought by Mr. Robinson must fail. To use her words, was bound to fail. So we were listening to the judgment and we were feeling quite good. Okay, he has brought a constitutional motion. She has ruled that the motion is bound to fail. We thought we were home and dry on the matter. And then all of a sudden, she goes into a different gear and decides to say, well, it looks like Mr. Robinson has satisfied the requirements for judicial review. I think he has a proper complaint. I think he has been adversely affected by what the Police Service Commission did. And because of that, I will grant him all of the relief that he has asked for. I am giving judgment. And she does so without a trial. I mean, this is what was most astonishing. You cannot come to court in a matter such as this, known as administrative law, where you just simply file papers and get judgment just like that.
Which brings me to the question, Dr. Dossett, did Mr. Robinson make an application? Are you saying, did he make an application to be granted permission in this case to make a judicial review claim?
No, it was totally off the cards. I mean, really? It was not hinted at. We had suggested perhaps that is what he wanted to do. Now, I think there is good reason why he would not want to do so, because he would face a very difficult hurdle to get over. Judicial review is only granted if there is no alternative remedy available to you. I mean, the court has limited resources. The court cannot just take on everybody who say they have a complaint. And the law has devised various mechanisms for persons who have difficulties and issues with public bodies to get remedies. And in this case, the Constitution itself provides a remedy for persons in the position of Mr. Robinson. There is a body established by the Constitution, the Public Service Board of Appeal. So if the Police Service Commission has, you claim has mistreated you, has made a decision against you on an improper basis, you go to the Public Service Board of Appeal. They will hear your case and make a determination. If you are dissatisfied with what the Public Service Board of Appeal has done, you can then come to court. But it's not a situation, I have a little complaint, let me just go and barge through the court door. It doesn't work like that.
Okay, so the issue of the judicial review claim in which he challenged his suspension before the termination, can that be continued in the High Court?
Well, the court has held that it is still arguable. We quite frankly think that we have a rock-solid case on that. I don't want to get into that right now. But we have put in our defense. The matter is set for, a hearing date has to be set. But in terms of all of the preliminary work, all of that has been done. All papers have been filed. He has, of course, filed his claim. He has filed his evidence. We have put our evidence in reply. It's a matter now for the matter to go to trial, and after trial, a judgment to be given. But in the case with Justice Anne Marie Smith, there was no trial at all. You see, and that is worlds apart. In one case, you go through the system. One side makes an allegation, the other side puts in evidence to refute it. The matter goes to trial, and the judge, upon hearing the evidence and considering the law, determines which side ought to prevail. That simply did not happen in this case. He just comes and makes a claim. No one is able to know if what he is saying is true. The judge has no way of assessing the veracity of what he is saying. The judge has no way of knowing what legal principles applies. She just simply gives judgments just like that.
So this is to say then that the appeal going forward, I believe then, maybe you can tell me I'm not a legal mind, that the judgment of of Justice Smith, are you saying that is going to be put aside and then a different judge from the High Court will hear and determine the Police Service Commission's application? Yes.
And ordinarily, if a party is aggrieved, let me put it like this. In principle, a party is not able to choose a judge. All right? You can't go judge shopping and say, I want this judge or I want that judge. Whoever is assigned your case, you have to live with that because you have to assume that the judge will properly discharge the functions of the office. Sometimes when a person goes to a court of appeal and the matter is remitted back to the High Court, sometimes, but not in all cases, sometimes the party may say, I would like this matter to go before a different judge. It happens sometimes, but not all of the time. But in this case, the Court of Appeal, I believe, being very disturbed by the manner in which this particular matter was handled, of their own motion, determined that this matter could not go before the same judge. It had to go before a different judge because, from start to end, everything was just not done according to precedent or principle. As the Chief Justice says, there was a conflation of various procedures involving these type of matters. Everything that could have gone wrong did in fact go wrong. It ought not to have been because it was a fairly simple case. Look at the Constitution. Look at what Mr. Robinson is complaining about. Does any constitutional right that Mr. Robinson has come into play? It does not come into play because all that Section 105 does, it determines the powers of the Police Service Commission. It does not determine the powers or the rights of the police service or of the Commissioner of Police.
Okay.
Pure and simple.
Did you tell us the day? What date was the judgment handed down by Justice Smith?
It was actually, we were in court on the 25th of March 2021, but when we got the papers later on, it was actually dated the 24th of March 2021.
In the number of years that you have been practicing, sir, is this the first time you're seeing a learned judge conflating important court procedures of this type?
Well, I have been in a number of appeals, and in my experience, going more than 15 years, I've seen a lot of decisions that have had to be appealed. But this one was kind of off the scale because, what happened in this case, what is remarkable is that judgment without a trial. And that is the point we want to emphasize. We don't mind, let me put it like this. If judgment is given and you don't like it, I can understand that. But at least before getting to judgment, the judge or the judicial officer tried the case. There was a trial. There was argument. You could put forward your case. You could put forward the evidence. And then after all is said and done, the judge may disbelieve you and say you have no case and enter judgment against you. But the basic principle of trial before judgment was simply passed over. And this is what is very disturbing. And as soon as we got the judgment, within 4 hours, we already had our appeal filed and our bundle up on the before the Court of Appeal, because as far as I was concerned, there was absolutely no way in which this kind of judgment could stand. I said, why not a conservative? When I heard what was coming down from the bench, I would have fallen out of my chair. Judgment without a trial.
No, and you're making me laugh here because it is really surprising that I'm hearing this. But pertaining to Mr. Robinson's judicial review claim, by which he challenged the suspension before the termination, you're saying that this can be continued in the High Court?
Yes, we had made an argument that the suspension was academic because it had been overtaken by the termination. So the court said, well, we're not quite certain about that. We will allow the High Court judicial review on the suspension to continue. And so that matter is set, a date has to be given for the trial. And then after trial, judgment. That is how it works. All right? Trial, then judgment. So we are awaiting a date for trial in that matter.
Okay.
After trial, judgment.
Okay. And I was supposed to, I thought about asking you, you said the 24th, the judgment was handed down. So what was the delay between then and now? No,
well, you remember we are in COVID times, huh? And so, you have to go via Zoom. And so the judgment may be ready. You give it a date, but because of technological or other issues, when you actually get on, it was a day after. So we don't have any complaint about that. That way, it's not a point of complaint because it is something that unfortunately happens because of the circumstances that we are under.
Okay. Mr. Prime Minister, you want to tap in on this, or you're going to just bypass and leave that?
Well, I'll just speak briefly. And having listened to Dr. Dorsett, who has emerged as one of our most competent attorneys,
Indeed.
I have no doubt that he would have provided good representation for the commission. At one point, I had suggested to Mr. Robinson that perhaps he could settle this issue out of court, but I guess it's his right to determine whether or not he wishes to continue to pursue it. In any case, I suspect that is probably Chaku Walker who helped to prepare his case, because Chaku has a propensity of misapplying legal and constitutional authorities and even conventions. In fact, the most recent one is when he said that if we were to introduce restrictions to force vaccinations, that he said that will be unconstitutional. He quoted he quoted I think Article 7 of the International Convention.
Yes, Article 7.
The rights to physical integrity. Now, he clearly misapplied the provision because it has been drawn to my attention by Tony Astafan that particular article speaks to Nazi human experimentation, in which a series of medical experiments on large numbers of prisoners, including children, by Nazi Germany in its concentration camps in the early to mid 1940s during World War II and the Holocaust. So, in essence, they would have targeted prisoners of war and disabled Germans and so on, and Jews from across Europe. So that is what it is talking to, that type of forced situation in which you use those individuals literally as guinea pigs against their consent. That does not apply here. But we all know that Chako is not a good lawyer. And that's why people like him and so on, they can't survive in opposition because they can't get enough clients to keep them busy. And look at a man like Dr. Court, for example. I'm sure he's doing perhaps even more legal business now in opposition than when he was in government. But people like Harold Lovell and Chako Walker, if they are not in government, they can't survive. Alistair Thomas, they can't survive. Sean Bird can't survive in opposition. So money them a look. Congrats to Dr. Dorset.
Dr. Dorset, I want to